welcome everybody. We're going to get started. The good news, as you know, is today is on a full half hour of professionalism. And so if anybody was short their hours, this will help a little bit. And next week, we have a special for our last webinar of the year. We have an EDI, Equity, Diversity, and Inclusion webinar for 30 minutes. And so if you're short on your EDI stuff, that can help as well. That'll be next week. And today's an important topic. It's looking at our life, our industry, our practice, our job, from our client's point of view, or as most industries call it, their customer. And so that is what we're going to be focusing on. So Ian, we have a poll, but I also wanted, even before that, just as an introduction, I want to just advise everybody about this fact. And just to give us some more context to why our customers, and I'm going to refer to them as our customers for a bit today, our customers are so important. Do you have, maybe you want to just mention this, which was brought to our attention, Ian, you brought it to my attention.
I'm not sure what was brought to my attention, but I would just make a quick comment and then you'll tell me what was brought to your attention was, you know, something that it's so funny, eh? At the end of the day, we have all, I'm doing this for more than 30 years. My dad did this for another 30 on top of me. And the client was #1 for good lawyers. And it's never changed. And it's something that we need to continue to pass on to every generation. And the client-centered focus is almost why we became lawyers in many respects. But the market is now telling us that the client has to be #1. And it can't be, we have to stay client focused. And that's a big part of why Jordy, you and I were so obsessed about eState Planner and getting some sort of software going, because you and your genius was showing clients what was going on in will making in a visual way. And that had to be sort of encapsulated in some sort of software. So I really, you know, with young lawyers, and I do the litigation work, obviously, when they walk in the door, it's, no, you don't worry about me. You worry about who's #1, and #1 is the client. And the more we keep that focus, the better off we're going to be as a profession. But what did I bring to your attention?
I've got up on the screen the fact that the Law Society Access to Innovation Project approved Willful.
Oh, I'm sorry. It's not on the screen. I didn't see it was shared. Sorry, I'm on the wrong.
Can people see my, Michaela,
now I can. Sorry,
yeah. Okay. Good.
That's my fault. I was on the wrong screen. Yes.
No problem. So Willful.
This, you
maybe
go,
just
you go.
Yeah,
you go, and I'm going to fill it. I'll fill it in.
Willful is an online make your own will program that has done very well as far as public knowledge and awareness. And the Law Society, our Law Society, has an Access to Innovation project. And maybe Ian, you can speak to that, how they approved Willful as the first participant, and in essence gave them some the legitimacy, I think, of the Law Society's approval.
Yeah, and look, this isn't a criticism of this program at all. It's a phenomenal program, and it's a first rate, and it's really the first time that the internet will making has come to a level of satisfaction that makes some sense. In my respectful view, when I first started practicing, my dad walked me down to the old Grand and Toy store and saw it was in those days, it was a turnstile sort of display of wills that you could buy in Grand and Toy. And he looked at that and he says, "That's where you're going to make all your money." And I was like, "Cool. Why is it? What do you mean?" And of course, it was a game show, and it was a gong show. I mean, in the sense that, you know, people were given documents and really didn't know what to do with it. Willful is a very practical and sensible tool that on an internet-based level, it's a tool that we all have to, you know, not just accept that it's there, but respect it. But what it sends to me, and what has been my modus operandi since I started practicing law is just that what are we adding value? How as lawyers are we adding value? And this is the clearest message law society is sending, and that is, first of all, paralegals were brought in for good reason. Access to justice is a foundational expectation of law society and as practitioners. Well, the first program that gets approved for the law society is willful. And if that isn't a message to all of us as practitioners to say, how do we differentiate from what is a legitimate and an appropriate product? How do we differentiate ourselves? The bell has rung, and it rang really loud on November 15th. And this innovation project program is, I've been involved with it in some respects as well, but it is the Law Society has said, look, access to justice is a priority one. We need to look for innovative tools that are out there to allow the public to get access to justice. And the fact that a will making program is the first one for them to have endorsed sends a clear message to the profession. And that is that we need to do more to show what our differentiation point is. And there's no legal advice that's being given on that program. And we need to show why legal advice matters. So that's just my little rant. So go ahead, Jordy, sorry.
So I just wanted to put that in perspective, that we better, we better up our game. And the Law Society is telling us that with that. So I thought we'd talk about how we treat what we know about our customers, our clients, and what worries them. What can we do to avoid them not coming to us and encouraging them to come to us, and those kinds of things. So that's going to be the agenda for today. So Michaela, do you want to maybe just before we get to that, do you want to throw up the first question on that? So we wanted to take a poll of our group and see what do we think is the number one worry. I mean, these may all be worries, but what's the number one worry that we think clients have when they sign up to do a will with us? And so we're going to take a poll, and this is unscientific, but let's see what we say here. So if everybody can vote, I'm gonna vote too. If I can do that, and we'll give it a couple more minutes, or no, I guess a few more seconds. Could everybody? I think it would be great if everybody voted. So if you get a chance, please do that. And if there's any problem with the voting, let me know. But let's close down the poll for now, and let's look at what the results were. It's 51% is the cost, and then there's other things like how difficult is this going to be, and what's involved. And I think we can do better. Certainly, we can do better on all three of those topics, and that's what we're gonna look at. So that's what we got. Okay, so I'm gonna just close that down. And so we know that how much is this thing going to cost is number one. We'll talk about that in a bit. I find that clients are worried about how long is this going to take? How complicated is this process? Will I understand all this lawyer talk? That's a worry for our clients. Do I have to tell them, how much am I going to have to tell them about my family and how the kids don't get along and how much money I have and all of those things? And you know what, these are hard to, like, how am I going to decide who gets my kids? Plus we've got the whole concept of really our topic of discussion isn't the most pleasant one. I don't really want to talk about my death. And what do I need to do this? And do I really have to do this? I think those are the major ones. And if anybody has other ones, please post them in the chat and we'll see. But these are the things that are worrying our clients before they even get to us. So what can we do to help them along? Ian, maybe before we jump on, any other things that you might think about on this front?
Oh, I like the list a lot. And the one thing I will say is this, is that, and I try to think about it in these terms, think about yourself going to see a doctor. And what is your reaction to that? Or think about going to see the dentist. Dentist is a little different because we kind of actually know some of the parameters, but especially if you have a general checkup or if you have a real illness that you don't know enough about at early stages. These are the kinds of feelings that you're feeling. And I always tell myself, what would I be thinking as I was walking into the doctor's office and remembering that the client is coming to see me is having a lot of those similar feelings? And how can I diffuse this? Because it's different. A doctor's paid by the government. We're paid as a private practitioner who needs to sell our goods and look like we are worthy of our advice. And the last thing I'll say is this. In my experience, it's remarkable to me, but unremarkable in its own way. People are prepared to come in that room and say things to you that they won't say to almost anyone in the world. And we have to respect that obligation. We have to respect the fact that they will almost certainly do that. Some will be reluctant, but most almost certainly will do that. And so how do we react to that, bringing empathy to the equation and bringing understanding? And those are the sorts of things that are always swirling in my head in every single new client meeting, Zoom or in person.
Yeah. And it's really a privilege for us. We are in a privileged position as advisors, as trusted advisors, to be entrusted with this information that they really don't want to talk about. I think of it like going to a doctor. I think of it like going to a mechanic. There's something wrong with my car. Do I need to fix this thing? And if I drop it out, like how much, I have no idea what this is going to cost and how long this is going to take. So there's a lot of this worry that we really should anticipate and try to reduce for our clients. So this is some suggestions on, what we can do to alleviate some of this. And we can explain the process. I mean, for somebody who's never done a will before, what is involved in this? Like, how many meetings are we going to have? Like, what do we have to do? All of that. We should also explain what we're going to do for them, what we can do. We're going to prepare wills or whatever, and what we're not going to do. We're not going to be able to tell them about their tax issues maybe, or whatever it might be. Some idea of the cost, I think, is really helpful. And we'll talk a little bit more about that. And then how long things will take, what you need them to do for this meeting, what you need them to send you, and really how wills work. Like, how does this process work to help them understand their decision making? And I think that's really what would be, an ideal thing to advise them before you even meet. Ian, anything?
Yeah, I know. Just the last point on that is just that, as much as you can, put it in layperson's and plain English terms. Like, I often will say, look, here's your homework. This is what you've got to do for me. And I call it homework because it's a term that everybody understands. Anything you can do to take away the res judicata of the world, or the whatever, the most recent Latin term that you can think of, keep that stuff out of the conversation.
Right. And we have a new poll. So let's see what you can answer. A whole bunch of answers here. What do we, as this group, what do we tell the client before we meet with them? So they called us, they're interested, and now we're going to tell them something about this situation. So let's see what we get here. And some of us, don't necessarily tell clients much about it until we meet with the clients. And so that might affect some of these numbers as well. And so it's good. We'll let the poll run for another few seconds here. And great. So there we go. That's our result in essence. And so most of us are talking about the process. Most of us are talking about the cost, which is interesting. And then there's the others. So that's, I think, a great idea. I think that really takes away a lot of the worry because, and maybe we'll talk a little bit about the cost, but maybe we can do that now. Let's just, because that was that was obviously one of the biggest worries, is, how do we talk about costs? And maybe I'll lead off, Ian, and then if you wanted to jump in. But so for this is just me, but I sort of give them a starting point. I say, look, a will for a single person, or wills and powers of attorney for a couple, or whatever, start at X. Because I think if you don't do that, and the reason I do that is because I don't want them to come to see me and spend time with me if they're expecting it to be, $100 or $200, and it's not for me. So that's what I do. And I say, look, it starts at that amount, and it's going to depend on a whole bunch of things, like, what decisions you make, and whether we're going to do, a corporate will and things like that. And I think clients recognize that, but at least it sort of sets the floor apart, because what you don't want to do is waste time with people who, when you do give them a quote, they're like, wow, that's 10 times what I thought it would be. I think that's not a bad idea. Other people give ranges, but Ian, any suggestions on talking to clients about those issues?
Well, I think on the solicitor side, early and often is important. And then so on the intake level too, it's to the extent that you can have, if there's an intake process that we'll talk about, advising that this is what we start at is crucial. Look, nobody wants to waste time, and nobody wants to waste a meeting. And you certainly, if you block off a new client meeting and the pricing is going to be the problem, then you need to know that sooner than later. And the solicitor side, for sure, it's more difficult. You get into complex planning and in litigation, but we've got to continue. I can remind myself all the time, I have to continue to remember that my dad always hated it when I said it, but law is a business, and it's got a business component to it. And and the truth is, time is money. So get it out front.
Right. And the more experience you have, the better sense you have of how to set your fee, whether it be an hourly basis, or whether you're charging for the meeting or you're not charging for the meeting, or those kinds of things. The other part I do is I try to set the fee, and I almost promise that I'm going to set the fee within a range after that first meeting. And so that's, I think, really helpful, but sometimes you can't do that, right? So, and especially if you've got a client who there's a lot of unknowns, answers to questions that are not out there yet, then obviously you can't do that. But I think the biggest fear, again, is how much is this going to cost? And lawyers, bill by the hour, and how, I'm terrified to talk to them, that kind of thing. And I think if you can come up with a way to do that, that's better. So the other thing that we do, and I saw that a big group of us talk about the process, and this is also really important. That how is this? They don't know what they're going to be in for. So these are kind of the steps that I would typically highlight with my clients in the when they first say, oh, I'm thinking of doing a will. What can you tell? Give me whatever. This is the kind of information I set out. And one of the things is the process. I'm going to, gather information from you, and then we get a deposit. You might not want to do that. And then we're going to have a meeting to discuss the planning. And then we're going to send you a retainer agreement to make sure you're okay with going ahead. And then we're going to prepare the documents, send you drafts, and how long that typically takes. And then we're going to review it, and we can change it and do all that. And then we're going to have a signing meeting. So at least this brief, and yes, there doesn't have to be that much detail in this. It says whatever you're comfortable with, but this really also helps focus the client on, what am I in for here? Are we going to have 7 meetings? Are we going to have 2 meetings? Do I get to talk to you? What kind of thing? Any thoughts on that, Ian?
Yeah, well, look, Jordy, the big part of my practice of law has been to follow everything you do and steal it. And one of the great things you do is whenever I refer a file over to Jordy, almost instantaneously, there's an email that goes out to the new client, and it says, thanks for reaching out. Here's our process. And he's automated 90% of those steps right there in the introductory email. So the client, before they get in the door, has great parameters. And that comes back to setting the stage efficiently. And remember, efficiency is the key here. At the end of the day, we've got willful out there. We've got We've got a competitive market that, you know, a process for someone to spend an hour and a half on the internet at 8 o'clock at night when the kids are in bed doing their own will and willful is very different time commitment than to do a will with a lawyer. So the more we can automate, the more that we can set the stage by automated information, the better it is. And you have that a wonderful opening email that you send out that sets out that process. And I seriously have cut and pasted it.
Yeah, I mean, it's really, it doesn't take me more than the time it takes me to hit send, really, because it's the same one, right? And almost every time a client gets it, they say, "Thank you so much for your detailed explanation," as if I had, you know, created that from scratch. But they really do appreciate it, and I think we can do a better job at that. And so we've got another poll coming up here, and that is really, what do we, before that first meeting with the client, do we, you know, do you ask for information about your client's family assets? Do you provide, or do you ask about the, maybe, I don't know if we can change this, Michaela, can we make this multiple choice? Is that possible? Can we pull it down and then put it back up?
You can change it now, Jordy.
Sorry, guys. Okay, you get your number one. So, you know, obviously
Okay,
most of us
sorry to interrupt, but how cool is that? Michaela can do that on the fly.
I know. Impressive.
Sorry, carry on.
So, yes. So most of us would pick number one. And I'm particularly interested in sort of people who do more like numbers 2 and 3, because that's interesting as well. And so certainly most of us are gathering information about clients' family and their assets. And some of us are providing substantive general information about planning, and that's what I want to turn to next. And Michaela, do you mind just pulling this down for a second and seeing if you could recreate it so that we can have multiple choices, and then we'll repost it? Sorry about that. That's completely my fault. I should have told Michaela about that. So the idea of, well, first of all, let's just talk about documents that they might need to bring or send. And this is also a good heads up that, look, you know, I'm going to need at some point, you know, your prior wills and powers of attorney. Important to get inter vivos trust documents, because we're going to need that at some point as well to make sure that we don't need to deal with appointing trustees or a power of appointment in an inter vivos trust. Insurance policy information. I mean, that's particularly important because we like to identify insurance policies when we're doing a designation. That's important. You know, separation, cohabitation, marriage agreements, shareholder and partnership agreements, and a corporate structure chart if you've got companies, a bunch of companies. Those are some key ones that we want to get, and we want to give them a heads up that we're going to need this. So if you can start gathering this information, that would be wonderful. I'm also going to need, I say to the client, you know, we're going to need your full legal names, at least yours, if nothing else, and any other legal names that you go down. We want to know, as far as financial information, you know, I want to know sort of the breakdown between registered assets and non-registered assets, and ownership of assets, which is so crucial for everything we do. You know, if they could do some homework on that before, again, we are balancing, you know, the idea of you know, how much effort they have to put in with what we need to know. But at some point, we're going to need to know ownership, because that's crucial to any will, right? So, Ian, anything on those points?
No, I think you nailed it. This is the toughest balancing act, and I think, in the will drafting process. That is, you know, how much do you torture the client before they get in the door? Because that can be a real barrier to entry. So that's something you just have to balance very carefully.
Yep. So the other thing that I do, and this was where we were getting at when we talked about substantive information. So I like to prep my clients, because I can save some time when I'm having the meeting, about things that we're going to always talk about. The structure of the process. We're going to talk about these 3 scenarios. What do you want to do if you die first and your spouse is alive? What do you want to do if you're both gone? What do you want to do if everyone's gone? I have this theory about the, two kinds of options for gifts, absolute and trust. And we've talked about that before. So I want to give them some background on that. I want to explain that a will is only valid when you die, right? And you can change it anytime. And I also like to focus the client that you don't have to think about, we're not going to think about every possible thing that could ever happen in the next 25, 50 years. Let's focus on what's going to happen if something happens to you in the next 5 years, because clients can certainly get overwhelmed with that. And one thing that I did, and I would encourage people to do this, is I made a short video about these kinds of things. And if you're interested in seeing it, it's Michaela, you can reach out to Michaela and she can show it to you. But it's just it's a 3 or 4 minute video that just says, listen, this is how we're going to plan your will. We're going to think about these 3 scenarios. We're going to think about these kinds of gifting and those kinds of things. And it's my clients watch it pretty religiously before the meeting, because I send it to them before the meeting. And it's really helpful for cutting down on the amount of explanation I need to give, because at least they have some background on it. And other people have other things that they explain about the substantive decision making in wills. Ian, anything?
Is that in a link to when you send out this is our process, right?
Yep. Yeah.
Nice.
I just say, to help you prepare for that meeting, here's a short will and a short video. And like I said, the vast majority of my clients watch that before they meet with me. And it definitely saves time, because I'm going to be telling them the same thing. I'm going to give them the context of this that every will is pretty much based on. So, here I just highlight, and we have just a few minutes, but highlight these key decisions. And they're going to be in the slide, but these are some of the key decisions that our clients are going to need to make. What do you want to do if one of you dies? What do you want to do if you're both gone? And this is usually what everyone's worried about. So, sure, there's 25 questions we can put on this list, but what are the key, 1 or 2 or 3 things that I'm going to want them to think about maybe in advance? What happens if everyone's gone? Often people don't think about that at all. And then, what about if you're incapable, and who's going to make decisions for you? And that's helpful for whether we collect that information or not, for them to at least address or think about it before the meeting. That's really helpful. And one of the things that was interesting, and you can maybe just post in the chat if you do this, do you ask the client for their quote instructions or wishes before you even meet with them? I've always been of the view that that's kind of what I don't really want to know what they think they want yet until I explain it to them, and then they can make decisions. But that is not certainly the majority view. And I just wanted to know if, who among us really reaches out before, whether it's in their questionnaire or otherwise, and says, okay, what thoughts do you have about if you die and your spouse is alive, or if you're both gone, or who do you want to be your executors, or those kinds of things, asking actual questions, which is of course very similar to what the online programs do, which is go through a series of questions and the client sort of answers them. And so I'm interested if anything you have there, if you want to post that you do or you don't in the chat. We have about 1 minute left, and then I'm going to answer. There's a couple of questions I will answer on the chat, but that really is, I think, a way, some thoughts, and there's many more thoughts, but about preparing our clients to meet with us in a seamless way, to remove some of those worries, because the better our client experience is, the more people that are going to be referred to you, and the success of our industry before we're we have to show value, as Ian said. Ian, maybe you have some thoughts on that.
Listen, I think we have an obligation to the public to make it a successful process. And as I say, willful is right in our face. So thanks, Jordy, so much for doing this. I'm going to jump off and let you answer some questions. We're at our Christmas party or holiday party, so I got to jump off.
Thanks, Take
Ian. Care. Bye-bye.
And just one, we have a couple of questions, but just a reminder that next week we have the EDI 30-minute webinar. It'll be our last of the year. Today's webinar qualifies for 30 minutes of professionalism. I'll just stay on and address some of the questions about fees and things like that, if you like. And if you want to jump off, please feel free, and wish you all well and have a good rest of the week. Wanted to clarify, there was a question about how do we reduce changes that are requested during the signing meetings. I don't make changes during the signing meetings because I have a review meeting where I go over everything. If there's anything outstanding, I follow up before the signing meeting. I don't want to be making changes. That's how we make mistakes at the signing meetings, and it slows down the process. So I tell them in our review meeting that we're not going to be making changes at the signing meeting. If they want changes, then we're going to need to reschedule. And so, that's really, I think if you tell them up front, it works pretty well. Because yes, signing changes at the time of signing can be stressful, it's error prone. And I try to avoid it just like you do. Then there was a question of basic range for standard and standard wills. I mean, they range all over the place. I think we did, you might be interested if you're thinking about setting fees. We had a program back in the spring, I believe, on when we did polls like this about what people charge. And you can find that one on our YouTube page. And we have that available for everybody. So thanks everybody again for joining us, and we wish you well and hope to see you again next week. Bye-bye now.